Welcome to the California Consumer Litigation Update, Key Trends and Compliance Strategies, hosted by our sponsor firm, Buchanan. My name is Diana Cohen. I'm General Counsel and Corporate Secretary at Dr. Bronner's Magic Soap Company here in Vista, and I am the immediate past president of the ACC San Diego chapter. And today we've got Jennifer Oliver, a shareholder at Buchanan. Her practice focuses on commercial litigation, defending consumer class actions, as well as advice and counseling on those matters. She also advises on privacy compliance and the use of ad tech and other technologies. Jennifer has a long list of accomplishments and awards, including 4 years in a row as super lawyer for antitrust litigation and 3 years in a row as a woman of influence in the law by the San Diego Business Journal. And she is joined by Natalie Pellet, a senior attorney at the firm who has significant experience in litigation as well, involving business disputes, consumer fraud and protection, website accessibility, and defending cases brought pursuant to Prop 65, California's unfair competition law, and the Song-Beverly Act. So we're very excited to have both Jennifer and Natalie here today. Please put your questions in the chat. They will take questions at the end. And with that, I will hand it over to Natalie and Jennifer.
Thank you so much, Diana, for the lovely introduction. Pleasure to be here with you all today to talk about consumer litigation, class actions, and also individual litigation with my colleague, Natalie. Diana mentioned one of the hot areas in consumer litigation right now is ad tech litigation. Many of you may be familiar with the other common brands of consumer litigation we see here in California, Prop 65, UCL, CLRA. We'll talk about those today as well. But the one that seems to give our clients the most pause and with which they're the least familiar is this new wave of ad tech litigation. And you don't have to be super tech savvy or a technologist to understand these claims or how to mitigate against these claims, which is what we'll focus on today. So I promise not to get too technical on you all. So what is ad tech? Ad tech is the technology that consumer-facing companies, typically consumer-facing companies, use to optimize their digital advertising campaigns. And ad tech tools are offered by all kinds of different advertising platforms: Meta, TikTok, Snap, X. We see LinkedIn has ad tech, Google has its own ad tech. These are all technologies offered by these advertising platforms to consumer-facing companies to help them oftentimes monitor what their users are doing on third-party websites and figure out who they should be targeting in their digital advertisements. So the types of technologies that fall under this umbrella include what we call pixels, which are just a tiny piece of code that is offered by these digital advertising platforms for free to consumer-facing companies who use their ad platforms. They can install them on their websites. It's a very plug-and-play type of technology, and in doing so, help them not only better monitor the conversion of their advertising, but also better target who they're advertising to. And then there's also cookies. I think we're all familiar, at least at a conceptual level, with the concept of cookies. And then there are other types of software that give rise to these types of claims as well, including chat software administered by third parties, where the third party may use the contents of that chat to optimize advertising, lead generation software, session replay software, etc. So what is a cookie? It's a small data file stored on an individual's device through their browsers. They exist in apps, they exist on mobile applications, they exist on websites. They can be first-party cookies, meaning they are cookies that are put on the site by the website owner, or third-party cookies, meaning from a third-party advertising platform or other third-party partner of the website owner. Cookies can be blocked by users. Many users do not block cookies or don't know how to block cookies, but it is possible. And third-party cookies are the ones that we're really focused on for purposes of litigation risk, because the concept that plaintiffs are focusing on here is, hey, if you're putting technology on your website that is sharing what I'm doing on your website with third parties without my knowledge and consent, that is an invasion of my privacy. And we'll talk about the specific statutes that plaintiffs' attorneys are using to bring these claims, but at a high level, they all come down to just that. What you're putting on your website and sharing with third parties, if you don't have consent of the user to do that, that's when you become at risk. And it's very important to work closely with marketing departments to understand exactly when that kind of sharing is happening, because I come across all the time clients, I'm talking to the legal department, I'm talking to C-suite, and they don't even realize the type of technologies that are running on their consumer-facing websites and the risk that is associated there. So pixels, similar to cookies, also a small piece of code. It's embedded in the website, but a pixel is always a third party, and it's hosted on a third-party server. So an example would be Meta's Pixel. Is integrated into your website, your consumer-facing website. You're using that to optimize your Meta advertising campaign, but the data from that pixel is being hosted on a third-party server on a Meta server. And this obviously presents a thornier issue than a first-party cookie, because now there's data about what consumers are doing on your website, but it's being collected by Meta or Facebook and hosted on their third-party servers, ostensibly without the consumer's explicit consent, unless you have a consent workflow on your website that actually collects that consent. So we see, by and far, the biggest targets for litigation are the Meta and TikTok pixels, although there's all kinds of other types of ad tech litigation that we're seeing as well. We're also seeing a new wave of litigation around SDKs. This is getting a little bit more technical, but all you really need to know is SDK stands for a software development kit. They're often used in building mobile applications. They're often third-party tools, and we're seeing more and more now lawsuits alleging that third-party software development kits are gathering information about what consumers are doing in an app or on a website and sharing that with the third party without the consumer's consent, and that gives rise again to an invasion of privacy claim. And we'll talk about exactly what those claims look like a little bit later, but that's sort of an overview of the technology. There are many state laws. Principally, we're seeing these brought under state wiretapping and invasion of privacy laws, but there's also a federal component. The federal government and FTC has historically held companies to account for making deceptive advertising and promises, and so they are involved here as well. We're not sure how much enforcement we're going to see under the new Trump administration, but this is a focus of the FTC and enforcers, as well as private plaintiffs, is what you need to know. So we're in California. So let's talk about the California state law claims that we're seeing in the ad tech realm. Most of these claims are brought not under the CCPA and CPRA, because you may be sitting there thinking, well, I know that we have advice from counsel that we are compliant with the CCPA/CPRA, and so we should be fine on this ad tech litigation. Unfortunately, not so. Plaintiffs have found a creative workaround to the CCPA's private right of action, which is very narrow, and they're bringing these claims mostly under the California Invasion of Privacy Act, mostly Section 631, but some other sections as well. And it's a very old statute. It predates the internet. And it is the statute that many of you may be familiar with that says if you are going to record a conversation in the state of California, you need the consent of both sides of that conversation. And now plaintiffs' lawyers have interpreted that law to apply to the internet, and the courts, as you'll see, are buying into this to say that what a user is doing on your website or your app is akin to a communication with you as the website owner. And it is therefore possible for you to aid and abet a third party, such as Meta, in intercepting or recording that communication without the website user's consent. And that gives rise to the SIPA claim. And what's scary about SIPA is the statutory damages. You don't have to buy a product. You don't have to have actual damages to bring a SIPA claim. All you need to do is visit the website while a pixel or similar technology is firing, and you have a claim. And so you can imagine how easy it is for plaintiffs' lawyers to drum up, even if you have a class action waiver and mandatory arbitration clause that's enforceable on your website, to drum up dozens or even hundreds of claimants to bring SIPA claims, each of which carry with them that per violation statutory damages of $5,000. So huge potential in terms of the ceiling of damages here, which makes it very appealing and sort of explains the huge wave of litigation we've seen in this area in recent years. Trap and trace claims are another brand of claim. 631 SIPA claims are the wiretapping type of claims. They're also bringing increasingly trap and trace claims, which allege that technology on a website is akin to a pen register device, like a device that law enforcement would use to tap a phone line. And the law says you need to have consent or a court order to tap someone's conversation with a pen register or trap and trace device. And now plaintiffs' attorneys are saying, wait, these cookies and pixels that are sharing my click flows and what I put into a search bar and what I put into a chat function, they're sharing these with a third party, and that is akin to an illegal trap and trace device. And the Southern District of California here, in this case, Greenlee versus Coachava, has allowed claims under that fact pattern and concept to go past the motion to dismiss stage, and that set off a whole new wave of trap and trace claims as well. Another thing to keep an eye out for, if your website utilizes on-demand video content and you have any sort of ad tech running on the website, you are also at risk for claims under the Video Privacy Protection Act of 1988. Again, very old statute predating the internet. Plaintiffs' attorneys are dragging it into modern times to apply to internet communications. The statute was passed after Robert Bork's Blockbuster rental history was leaked during his confirmation hearings, and Congress came in and said, wait, we don't want our video rental history to be public, and so they made it a violation of the VPPA if a videotape service provider knowingly discloses any sort of PII concerning any consumer without their consent. And so courts have now interpreted this to mean if you have on-demand video content on your website and the fact that a website user viewed that video is shared with a third party through your third-party cookies, through your third-party pixels, or otherwise, that can constitute a violation of the VPPA. And again, the scary thing about the VPPA is statutory damages of $2,500 per violation. You can imagine if you're looking at a class action of every person who has visited your website and viewed a video within the statute of limitation period, that can add up very quickly. Okay, so how do we, and we'll talk more about assessing and mitigating risk in all these consumer cases a little bit later, but I want to talk quickly about how to assess and mitigate risk in ad tech litigation in particular. So the most important thing, which I touched upon earlier, is to assess and inventory your use of third-party cookies and ad tech running on your website. So when the tech fires, what's being shared with third parties, we see so often that legal departments and C-suite do not fully understand what's running on websites. We have a disconnect between marketing teams and web teams and the legal teams in that regard. And the first time everyone understands what's going on the website is when they receive a complaint or a legal demand. So important to understand what's going on the site. Disable tech that is not in active use for campaigns. I have seen several clients get sued related to technology that they were no longer using. Maybe it was implemented for a specific campaign, it's no longer being utilized, and here they are facing a lawsuit. So very important to make sure you're disabling that tech that's not in use. Update the privacy policy. This is an important one, but it's also important to note that having an up-to-date privacy policy that discloses exactly what you're using on your site alone is not sufficient to guard against these claims. Many of you are probably familiar, and I think we'll touch upon later, with the concept of click wrap and browse wrap. And that is the idea that having a policy or a terms and conditions on your website down in the footer without getting any affirmative assent from the website user to those terms and conditions, to that privacy policy, is probably not going to hold up in court. You're not going to be able to point to that privacy policy and say, look, I told them exactly what I was doing on the website and they agreed. Maybe you told them, but they didn't necessarily look at it and they didn't necessarily agree. So what do we do about this? Consider implementing a consent banner. We are probably all familiar, as people who use the internet, with the increasing proliferation of cookie banners. When you get to the site, that thing pops up and says, we use cookies, you can manage your cookies here. That consent banner can help mitigate your risk on all of these types of claims, and also help you to enforce any mandatory arbitration clauses or class action waivers that you have in your terms and conditions, if it is implemented correctly. So you want the consent banner to collect explicit consent to use of third-party ad tech before the technology fires. If the technology is firing the second you land on the homepage, before the user can consent, then the consent banner is almost useless. If you can suppress your technology until the user gives consent on the cookie banner, and if you can also include a link to your terms and conditions and your up-to-date privacy policy that discloses exactly what technology is on the site, and get the consumer's consent to those policies in your cookie banner as well, then that is going to go a really long way toward mitigating risk of these types of claims. If the user can just X out of the banner and continue onto the site without interacting in the banner with the banner, that might mitigate your risk a little bit, but you're still going to have a lot of people who could say, well, you put that banner in front of my face, but I didn't say consent. I closed out of it and thought that you wouldn't collect my data unless I said okay. So marketing teams don't really like to force people to interact with the banner before they can proceed to the website, but that is the best practice if you want to mitigate against these claims. You know, as anything, it's a business decision. It's also going to help you if you want to enforce a mandatory arbitration clause and you have that in your terms and conditions. Don't think that you can have a mandatory arbitration clause and class action waiver in your terms and conditions without getting affirmative consent and then be able to enforce that when you get one of these claims. If the user has not consented, you are most likely going to lose your motion to compel arbitration under those facts. And also be aware of the mass arbitration approach, which is very common in these cases where there's no barrier to entry to bring a claim. All you have to do is visit a website. You can enforce your arbitration clause and then be faced with dozens of individual arbitrations in front of different arbitrators, each of which force the business to bear most of the arbitrator fees and filing fees, and that becomes very expensive as well. So it's not necessarily a cure just to be able to enforce your arbitration clause. And also be aware that the high-risk sectors for this type of litigation include retail and healthcare. We see retail using ad tech very often. They're trying to sell a product. They want to advertise in people's Facebook and Instagram feeds. And so we see a lot of claims in the retail space, but also healthcare because it is such sensitive information. I think many healthcare providers are now in tune to this and making sure that their web portals for their patients and potential patients are not using this type of software. But we saw for a while a lot of hospital systems, doctors, online pharmacies using this technology, and then plaintiffs alleging that, you know, their sensitive healthcare information, you know, the mental health drugs or the like that they were searching for on a website were shared with an advertiser without their consent. And obviously that's a very sensitive area and a focus of the FTC as well. So talking briefly before I turn it over to Natalie, a little bit about false advertising litigation as well. We see a lot of false advertising litigation in California in particular. The latest brand of false advertising litigation that seems to be the new trend or the new sort of focus of plaintiffs, so that we haven't seen a huge volume of it yet, is greenwashing litigation. So again, if you are a consumer-facing company, you need to be careful about the representations that you're making on your packaging, on your website to consumers regardless, but especially in the area of sustainability, things that you're claiming are natural. These are a definite focus for false advertising lawsuits, and not only by private plaintiffs, but also the Attorney General and the FTC. So in 2022, the FTC announced that it was undergoing a review of its green guides, which give guidance about the types of representations companies can make in the area of sustainability and environmental claims. And the Attorney General is also currently focused on this and recently announced an investigation into 6 of the big oil companies, seeking to make them give up illegally obtained profits that he says were gained through illegal greenwashing activities. We've seen private class action lawsuits in this area as well. For example, one against Keurig Green Mountain that settled for $10 million under the California UCL. Plaintiffs there claimed that Keurig had falsely advertised their K-Cup coffee pods as recyclable when they were not. And so, this one's fairly easy to understand, but just really important to always be reviewing what kind of representations marketing is putting on labels, on websites, in any sort of advertising campaign with an eye toward greenwashing. So assess compliance with the FTC green guides, make sure your representations are specific and simple, qualify them where you need to, assess everything, even the use of colors and the use of the color green. And again, you can consider that mandatory arbitration clause and class action waivers, but to sort of mitigate your class action risk, but beware of that mass arbitration approach as well. There is a little bit more of a barrier here because plaintiffs generally need to have purchased the product in order to make the claim, but still a relatively low barrier to bringing the claim in these types of cases. Other types of false and misleading pricing litigation that we see regularly, strike-through pricing. This is a big one right now. If you are a consumer-facing company that is using perpetual sales or always has an MSRP crossed out with a better price below it, or uses the comparison pricing, compare at X and our price is Y. This is a huge area for plaintiffs' lawyers right now. They are alleging that perpetual sales and strike-through pricing can be misleading if the reference price that you're using is not an actual price that was offered, say, within a significant amount of time within the last 90 days. If the so-called sale is running, 6 to 8 months out of the year, then they're saying it's not a real sale. It's just a misleading price. And so always important to take a look at your sales, your marketing, and your pricing and make sure that you're monitoring whether what you're comparing it to is a real price that you can show was offered in the marketplace, and that the sales are actually sales and not just something that is running all the time. Also focus right now on drip pricing, junk fees, not only by private plaintiffs, but also by the Attorney General. And there's a recent amendment to the CLRA that prohibits advertising, displaying, or offering a price for a good or service that does not include all mandatory fees or charges. So that's the drip pricing. You see one price, and then as you continue through the checkout, there are additional fees, charges, and you don't find out the actual price until the end. Big crackdown on that right now, and it is a focus of plaintiffs' attorneys. What are the damages here? Usually, it is the difference between the price that was paid and the price that would have been paid by the consumer had there been full disclosure. But there's also injunctive relief, the possibility of punitive damages, and also attorney's fees. So can add up very quickly there. As I mentioned, this is not just private plaintiffs, but also the FTC is focused on misleading pricing. This is not a private right of action, but nobody wants to be the subject of an FTC investigation. But the FTC, as I mentioned earlier, is charged with consumer protection and does require that any reference price advertised be the actual bona fide price at which the article was offered to the public on a regular basis for a reasonably substantial period of time. So again, the benchmark that we use is 28 days in any 90-day period. And that can be very difficult to monitor on a rolling basis, but very important to be consistently reviewing pricing practices and have some way of monitoring as well. In the private space, we see these claims being brought under the Consumer Legal Remedies Act, the California Unfair Competition Law, and the California False Advertising Law. And it would be very common to see all three of those pled in a single case. So just a few examples here. I'm not going to go through all of these examples in painstaking detail because you'll have access to these materials if you want to look at the cases. but there have been large settlements in this area, $10 million by select blinds for alleged limited time discounts that were actually available all year. Hot Topic advertising 20% off site-wide for more than a full year. Michael Stores offering discounts on a perpetual basis are a few examples. The way to assess and mitigate risk here: caution your marketing team. Keep an eye out for MSRP prices. If the MSRP price is never actually used and offered by you in the marketplace, that is something that you need to assess. Sometimes pricing disclaimers can mitigate risk. So you can have sort of a little question mark and a circle next to your price where the user can hover over and it discloses MSRP prices are just that, but may not have been offered in the marketplace and so forth. If you want to continue to use strike-through pricing, that is one way to at least mitigate risk of these claims. And avoid advertising that just creates any sort of false urgency. So the FTC is very focused right now on what plaintiffs call dark patterns, which is creating any sort of pressure to buy immediately, but with sort of a meaningless deadline that just resets when reached. Okay, I am going to turn it over now to Natalie.
Thank you, Jen. So the Song-Beverly Act, we're all familiar with it. It's known as California's Lemon Law Act, mandates that after a consumer purchases a product, if the product doesn't meet the required specifications and there have been repair attempts, but repairs were not successful, the company has to either refund the amount or give a new product. But today we'd like to focus on a slightly lesser known aspect of the Song-Beverly Act, somewhat buried in Section 1793. And we have up right now, it's from two different websites, even though it looks connected. And hopefully what's wrong with this picture immediately jumps out to everyone. What's happening here is that these, in particular, these are product cards and website entries, and they are suggesting to consumers, quote unquote, register to activate your warranty. Intimates that the consumers must register and give up their personal identifying information in order to access the warranty. That's, of course, a big no-no. If we go to the next slide, thank you. In a recent class, there's the language from Section 1790 up there. In a recent class action, plaintiffs purchased products, claiming that they purchased the products because of the advertised, in this case, it was a limited lifetime warranty. And when they opened the product, they found product cards, which, yes, included the language, activate your warranty, register your product. The plaintiffs alleged that they assumed that if they did not register their purchased products, they would not have access to the warranty. That was not the case at all. Interestingly, the plaintiffs did not allege that they had attempted to access the warranty, that they felt chilled in accessing the warranty, or even that there was anything wrong with their products. But they survived a motion to dismiss, and the case settled on a claims-made basis shortly thereafter. Of course, there is an attorney's fee provision in the Song-Beverly Act. So, plaintiff's counsel walked away with an award in the multiple six figures, even though the case was at such an early point. So what's the company to do? Do not in any way tie the registration of the warranty to getting, registration of the product to access to the warranty. We suggest possibly including that language. Failure to register your product purchase will not diminish your warranty rights. Again, this is about talking to those marketing departments who are very eager to get the consumer's mailing address or email, but need to be contained. Some suggestions have been brought up about tying it instead to access to coupons or something like that. Just very important not to tie it to the warranty. We could go to the next slide. This is, of course, Proposition 65. We're all familiar with it. Requires businesses to provide warnings. if it's clear and reasonable warnings, if a consumer using the product might be exposed to any of, I believe it's over 900 chemicals listed by the California government at this juncture, which they believe could lead to an increased risk of cancer or some negative impact on fertility. So practically, as we all know, this law is enforced by a network of plaintiffs' attorneys who go out there, buy products, test for trace elements of any of the chemicals. They generally only buy products with no Prop 65 warnings on them. Should they find any trace elements, a notice of violation followed quickly by a complaint. Most of these cases settle early, although not necessarily cheaply, because of the burden of proof issues. Once a plaintiff shows that there's exposure to a chemical and there was no warning, the burden shifts to the defendants to either show that there was no increased risk of cancer or negative impact to fertility, or that it was within a safe harbor limits. These are, of course, very difficult to prove, very expensive. You get into experts. It verges on impossible to prove. So that has led a lot of companies, understandably, to throw, at the very least, short form warnings on their products, which previously stated just either, warning, cancer, and a citation to the Prop 65 website. That will not be effective or allowable after 2028. The statute came into effect this year, but there's a 3-year opportunity to get those labels into line. The labels will now have to include an actual chemical name. So those companies that were just throwing the warnings onto their products without testing and figuring out which chemicals, if any, the consumers were actually exposed to, that will no longer work. There are also new warnings required for passenger and off-highway motor vehicles. Very sort of rote, but new. Interestingly, businesses have complained that, this is a California regulation, but it's not targeted to California residents. Now, companies may put the word CA before the warning, or that California warning specific language before their warnings. Of course, there's no requirement that the suggested language is the language used for the warnings. The statute just requires that the warning be clear. Most companies choose to use these suggested warnings because if it ever comes to litigation, the company will have to show that the warning that they chose to use was just as clear and understandable. Of course, as we all know, even if you're just a manufacturer, the burden does not shift to the retailer. You have to provide the retailer with the warning labels and postings to put up if it's not on your packaging. And then you also have to make sure that the retailer will go ahead and post those warnings. In the cases we've seen, these notices go to the manufacturers and the retailers, but for the most part, the retailers and manufacturers generally have some indemnification clauses in their contracts, which we will touch base on later. And it's generally the manufacturer that ends up fighting these cases to the extent that they are fought. If we could go to the next slide, please. Thank you. So PFAS. I'm going to look down to make sure that I pronounce this correctly. It's the perfluorinated and polyfluorinated alkyl substances. There are thousands of them. So yeah, there are thousands of them. They are known as forever chemicals because of how long they stay in the environment and in our bodies, may lead to a whole host of medical problems. The first rounds of litigation and regulation dealt with PFAS in water. But this new round is focusing on getting PFAS out of a variety of consumer products, ranging from textile to products used by children to makeup, so on and so forth. California has quite a number of PFAS regulations on the books, but we wanted to highlight a couple of them. I mean, some that you're probably familiar with already are the AB 2771, which focused on 13 PFAS chemicals that cannot be in cosmetics, AB 1200, which banned using food containers that contained PFAS and also included a number of warnings that manufacturers of certain products had to include, cookware being one. But these two regulations that we've chosen to highlight here are new and important in the sense that, for example, AB 347, it's being seen as the regulation that's giving teeth to a lot of these other prior regulations. It's providing enforcement mechanisms. It established the office that is going to be in charge of going after violators. It's the California Department of Toxic Substances Control. And they are also, the good thing about that is that they're going to start publishing actual methods and explanations about the regulations. Those of us who are in the Prop 65 space are generally quite grateful for the information put out by the California government on Prop 65. The website is very comprehensive and has a lot of tips for companies to use in order to be able to stay within the regulations. The other thing that we wanted to really highlight for you here, if you look at AB 2515, which prohibits companies from manufacturing, selling, or distributing menstrual products that contain regulated PFAS. Now, what does regulated mean? Currently, it means intentionally added in a product, which, as you can imagine, is fairly easy for a company to discern. But starting in 2027, that will change. And the focus will be, instead of intentionally added, on the actual number of PFAS particles. And it's going to be a pretty scientific term that I do not fully understand, but the change is California is actually one of the few states that will be setting specific limits. It's going to be measured in total organic fluorine, and I cannot give you any more information than that. But the thing that makes it a little bit difficult is that companies will now be forced to continuously monitor and audit their processes, test their products. It's no longer a case of, for example, I'm a cookware company, I intentionally add PFAS to make my pans non-stick. Once it's not about intentional adding and it's just what's in the product, I have to worry about cross-contamination, maybe third parties adding chemicals that I'm unaware of in order to stay within the limits of the regulation. So that's going to make things a little bit more complicated. We do not expect enforcement to be immediate. I think there will be perhaps a few test cases. But it's coming for us all. We're probably all aware of the law in Minnesota that has barred PFAS completely in certain products, including cookware. Rhode Island and I believe Vermont have similar laws coming up. New York and California are very focused on getting PFAS out of consumer products, out of products that children use. So if you are a company that manufactures or sells or is any way involved with a product that's going to end up in a consumer's hand and may have PFAS in it, this is a developing area, and the plaintiff's bar will be all over it, not only via these regulations, but also Prop 65, since a number of PFAS chemicals are in the Prop 65 list, and we expect that more will be added. Okay, I think we can go to the next slide. Thank you. So the Yelp law. It's the regulation's name is 1670.8. It was originally created to protect consumers who bought a product or had a bad experience, wanted to put their negative review online or share it, and were, face negative consequences from the businesses. This law has actually been on the books for over a decade. Nothing much came of it, but recently there have been a spate of class action lawsuits. These plaintiffs are going on websites. Not all the websites they've targeted sell actual consumer products, but all the websites have terms and conditions, and they are focusing on basically random words in the terms that could be used to suggest that the company will seek retribution against the customers for posting negative reviews. We've seen them focus on language that's in the terms for barring content that is discriminatory. We've seen them go after language that focuses on copyright violations. They tie any number of things to other things that the terms usually say about the ability to terminate people's memberships or ability to access the website. And they claim that that this is a violation of the Yelp law. Now, interestingly, the majority of these cases were removed to federal court, where defendants had very good outcomes with motions to dismiss. Then the plaintiffs came back, argued that they didn't have Article 3 standing because there was no injury. And that is true. None of the complaints that we've seen discuss a situation where a plaintiff actually submitted a review somewhere and then faced negative consequences or some kind of enforcement from the company. The complaints don't even argue that plaintiffs were chilled or that they had a bad experience and they wanted to put a negative review but didn't do so. So yeah, they won those motions for remand. And they went ahead and all of those cases were remanded. The motions to dismiss were vacated, and now we are in state court. There have been a number of positive decisions for defendants, specifically out of Los Angeles Superior Court. All of them have been appealed, and we are waiting to see some more guidance from the Court of Appeal. What can potential defendants do in the interim? Go and look at your terms and conditions. If there's anything in there that suggests that someone leaving a negative review could face some bad outcome, whether it be removal from the website or inability to access certain portions of the website, that language needs to be clarified. I know we're going to taking questions at the end, but I did see something pop up about Airbnb reviews. For the most part, or all that we've seen, Airbnb reviews speak negatively about the property and not about the website. Also, there's been no case that we know of, or if it's out there, the plaintiff's bar will find it, where a negative review was left and then the website moved to somehow impose some kind of negative consequence on the reviewer. And that's what the Yelp law is there to stop. So I hope that addressed your question. I only saw what popped up. So if it was more in depth, we will deal with that later. I think we can move to the next one. Okay, so we are going to sort of fly through some risk mitigation and litigation strategies. California is a very special state. I'm originally from New York. It's also a special state. The plaintiff's bar is strong in both states. It keeps us on our toes, keeps us employed, so it's all good. But there are some things that we could be doing. In terms of your vendors and service providers, check your contracts. Are you appropriately allocating risk? Are there indemnification clauses you can rely on, or indemnification clauses that shift responsibility, quote unquote, the wrong way? just be aware of what you're signing. We see a lot of companies that deal with third-party marketing, companies that do their marketings for them. And if you don't know what they're doing on your behalf, that doesn't mean you won't be responsible for the negative consequences. As we note, government investigations often lay the groundwork for follow-up litigation. As Jen noted, nobody wants to be the object of an FTC investigation. And if you are, it's very likely that your problems will not end when that investigation is over. A second aspect of that, I think we can go to the next slide, thank you, is providing trainings. Do you know what your salespeople are promising people? Are your marketing folks potentially creating or running sweepstakes without official rules? Again, with when we retain other agencies to do work for us, the liability remains with us unless it's contracted out. In terms of the business units, of course, particularly for in-house folks, you have to get business people buy-in. That's not easy. It's not easy to always be the naysayer and bring up potential problems, but that's what we have to do. Sometimes they are more willing to take on board what you have to say when they know that you're very familiar with their goals and what the particular business unit is trying to accomplish. I think we spoke about data privacy, cybersecurity, all important and all part of an overall health and safety check that we recommend every company goes through. I think we can go to the next slide. So again, it's the early case assessment. Is it going to be a situation where we should settle this for a nuisance value? Are we going to be able to get out on a motion to quash or a motion to dismiss due to if it's a website and we can convince the court that there's no personal jurisdiction here? Is it worth it? Is this going to be, can we settle on an individual basis? I know Jen spoke a little bit about class action waivers, and I think maybe she'll get into it in the next slide.
Yes, so you want me to talk about class action
I
waivers,
think
Natalie?
it's
Okay.
basically a repeat, I think.
Yes, it is. So mandatory arbitration clauses and class action waivers, we see many clients have these in their terms and conditions, have for many years, don't think about them much and assume that they're going to be enforceable. First of all, they're not necessarily enforceable, as I talked about earlier, unless you have affirmative assent. But also the plaintiff's bar has adjusted to the mandatory arbitration clause and class action waiver and is very good at gathering mass arbitration plaintiffs to bring claims. Dozens or hundreds of claimants. It's very expensive. Many businesses who have these clauses in their terms and conditions don't realize that if and when that happens, they will bear the majority of the fees. Under the consumer rules of AAA and JAMS, the consumer typically only pays a few $100 filing fee, and the rest of the filing fee and all of the arbitrator's fees are then borne by the business. And this is because JAMS and AAA are seeking to make mandatory consumer arbitration a fair process, but it gives plaintiffs the ability to bring claims in mass without too much financial hurt. Also, claimants who meet a certain income standard below a certain income pay nothing at all. So it's very easy to gather claimants to bring claims. There are now mass arbitration rules, but those don't kick in until you're facing 25 or 75 claimants respectively. So think about your mandatory arbitration clause. If you determine that these potential downsides are worthwhile, make sure that it's actually enforceable and that you're getting assent. Otherwise, you're probably looking at the worst of both worlds, meaning that you can have consumers come and file mass arbitrations and then have someone file class action in court on top of that and lose your motion to compel arbitration. And so you're facing a mass arbitration and a class action. Twice not as fun. So just something to make sure you're looking at. Natalie, do you want to cover this one?
Sure. So basically, just stuff we touched on before. With early settlement, when possible, you are able to keep that confidential as well. We always include that where applicable in our settlement agreements. We're often able to include a provision whereas the plaintiff's counsel agrees that they haven't shared information about this potential case with other potential plaintiffs or other law firms, and that it's not going to be a case of, we knock down this one claim and there's going to be another one down the line. And we've had pretty good luck with those. Again, in repeatable cases, very important to closely consider the consequences of taking certain positions. We always like to discuss the personal jurisdiction issue because you may not find it important to bring that up and have no problem waiving that defense in some cases, but if there's a potential for larger cases down the line, it gets a little bit more difficult to claim that there's no general or specific personal jurisdiction when plaintiffs are able to pull up cases in the same state with similar facts where jurisdiction was not discussed or was actively waived. Not impossible, but gets a little bit more difficult. Again, with the class settlement, claims made settlements, we like them when we can get them. There's a little bit of a push away from those. And of course, you want to make sure that you're not going to get dinged for or that your administrator is not going to get dinged for not reaching out to as many possible class members or as many class members as possible and getting as many claims as possible. The nice thing about class action litigation is that when you're at the point of settlement, usually the counsel on the other side is very happy and willing to work with you, and you're both heading towards a similar goal of just trying to get the settlement approved. The giving plaintiff's counsel credit for business practice change, for example, in that Song-Beverly Act case we were discussing, it went down on paper as because of this action, our product card no longer says this, the internet web-based pages say this instead, and that has value, which will also help those settlements get approved.
Yep. All right. Thank you, Natalie. And just for those of you not familiar with class action litigation, the claims made process is one in which you as the defendant only pay for the number of claims that come in. So if there's, 50 claims for $1 each, you're only paying out $50. The other sort of model that's commonly used is this sort of pro rata model where you say, okay, the settlement's $100,000, and no matter how many claims come in, it's going to be divided pro rata between those people. A lot of times defendants like the idea of claims made because they think that there's not going to be a lot of claims, and oftentimes there isn't. It's more and more frowned on by the courts, as Natalie mentioned. You're more likely to get away with that in state court, which kind of brings us to another sort of strategic consideration, which is when you get that class action filed in state court, do you want to remove it to federal court or not? And there's some pros and cons, right? A lot of us like to be in federal court. There's a higher pleading standard in federal court. State courts in California require judicial approval of any voluntary dismissal of a class action. A lot of defendants don't like that, so they want to go to federal court where that's not required. However, something to consider is once you remove to federal court, you're no longer going to be able to argue lack of Article 3 standing for lack of injury because you just avowed yourself of the jurisdiction of the federal court, and the courts don't like when you do that. Say, no, this is where we belong. This is who has jurisdiction, and then turn around and say, no, you don't have jurisdiction because there's no Article 3 standing. So that's something to consider as well. So it's very important early on to think through all of these things, even when you're deciding about something like removal or whether you want down the road to consider doing a claims made settlement. So we do have a a short section on best practices for in-house counsel. These are very sort of a little bit more high level, and I would say, probably cover some things that many of you already know or do. And so before we move to that final section, I did want to open it up for questions since we have 5 minutes left and we want to be respectful of everyone's time. If you have any questions, please go ahead and put them in the chat and we can see the chat. If there are no questions, then I will quickly cover these best practices for in-house counsel, and we will let you all get back to your day. So anyone have questions? Okay. Seeing none, I'll move on. If there are questions, still feel free to put them in the chat as we move forward. But to wrap up, best practices for in-house
Jennifer,
counsel.
sorry, one question did just
Oh,
pop in.
I see it. Okay.
Yeah.
Use of AI in consumer litigation. So there's always, this is probably the first presentation you've been to in a while and didn't have an AI section. So there are many, I think, sort of possibilities regarding how AI will make its way into, the use of AI will make its way into consumer litigation. The main one that I can think of, and I haven't necessarily seen a big wave of this yet, but will be around employees' use of AI and inputting personal information, sensitive information, proprietary information into third-party AI tools. So, we've had many clients recently reaching out to us saying, please help us develop a policy around our employees' use of AI. They're concerned about legal's use of AI and HR's use of AI in particular. There are many AI tools, by huge companies, whoever's using Google, for example. Google is really pushing the rollout of its AI tool, Gemini, but that tool is capable by default of recording every video call that you're in and emailing out a summary of that afterward, for example. And that raises all kinds of issues, not only the type of wiretapping issues that we were talking about earlier, if you're recording those conversations without consent, but also privilege issues. And where is this recording being stored? And is that repository where the recording is being stored accessible by people who shouldn't have access to the information or the contents of what was discussed in that meeting? And who's receiving the email summary of the meeting afterward? What if there's a group in a call and some of the participants drop off, the rest of the group continues to discuss something, especially in the HR or legal context, that should not be heard or accessed by the individuals who left the call. And then the AI tool creates a summary of the call and emails it to everyone who was in the call, including the people who dropped off. These are all kinds of thorny AI issues that can give rise to consumer litigation around wiretapping, cybersecurity, invasion of privacy, potential data breaches if PII is put into these tools and disclosed to individuals who shouldn't have access to it. And also even, antitrust and unfair competition type claims if employees are putting proprietary information, pricing information, customer lists, bids into AI tools, and those tools are not proprietary and locked down in particular to your organization, and your competitors could be alleged to have access to that information, you're looking at potential antitrust and unfair competition issues as well. So I think we could probably do an entire 1-hour presentation just on AI and consumer litigation and all of the risks there, but those are a few that come to mind. If your organization's using AI tools, especially if they're not proprietary, it's key to really think about who is using them and how, and having really strong regulations and policies around the use of those tools.
Absolutely. And I will also jump in to say that we are starting to see some threats of all AI information being discoverable, everything your employees are typing in, the questions they're asking. And just to beat that same drum that we've been beating throughout, you need to look at your contracts with your third-party vendors. Are they using your data to train their AI models? That's something that you should also be considering.
Yep, and here it is. Consider impact of AI in your discovery processes. Discovery is already a nightmare between Slack and all the different software programs that a typical larger company is using internally every day. I can't imagine how much thornier it's going to get with AI. So I hope that answered your question. If not, please feel free to reach out to Natalie and I. Our information is here. We're so glad that you joined us today. Hope that you found this useful. Again, don't hesitate to reach out, and thank you.
Thank you, everyone.